like it could be both, it could be symbol, it could be words that are legally registered to use, like for use to represent a company, a brand, a logo, depending on what you want to register. Depending on the class it falls under. Let's put it that way. So a trademark is a symbol, word, or it could be both that are legally registered to represent a company or brand or a service. So it is a unique and recognizable sign or word, and like I said earlier, it could be both that distinguishes your product or services from other products, or distinguishes your product from other competitors. So a trademark is a distinctive symbol. It distinguishes it from other products, from other services, where when people see your product, because of the symbol, they know, oh, this is you. Oh, this is Pepsi. When you see Pepsi, this is Pepsi. This is Coca-Cola. Most times it's the symbol that distinguishes it. Sometimes it could be word, like I said, it could be both. It could be a symbol, it could be a word, it could be phrase, it could be design, or combination of both. So it is used to identify and distinguish the goods or services from one entity in a marketplace. Registering a trademark, it provides the owner legal protection, and it excludes other people or a third party from using that same mark, or it excludes other people from infringing on your intellectual property rights. So upon registration of trademark, exclusive ownership of the trademark is being conferred on the proprietor or the owner. That's the trademark owner. So it could actually be an individual, a sole proprietor, limited, so which enables the owner to enjoy full benefit and protection provided under the law. There are certain benefits that a trademark proprietor actually enjoys, which exclusive ownership is one of them. So once you register your trademark, or once a business registers its trademark, or an individual, it could be sole proprietor, it could be an individual, it could be a limited, which is the company. So once they register once it has been registered, another company cannot use that logo or that symbol and logo without asking for your consent. So where another company or enterprise registers the same logo or mark, then it will be considered as an unlawful, and the rightful owner can actually sue for infringement of right, and it can also lead to legal issues for both parties. Imagine you infringing on someone's right, and imagine it was my intellectual property rights you're infringing on. I can actually sue you because I'm the only one that has exclusive rights to this logo since it has been registered. You cannot claim exclusivity on a mark or a logo that has not been registered. That is where the protection comes in, protection of the law comes in. So unlawful use of a registered trademark, because that's basically what the topic is all about. Unlawful use of registered trademark, it revolves around when an unauthorized or improper use of trademark that has been legally registered. When you use a trademark that is legally registered with the appropriate government body, then you are basically using the trademark unlawfully, or you are infringing on the rights. So today's topic, I'll be using SANOFI as a case study. In case you've not heard, there was a recent case where a French pharmaceutical company sued two companies, one enterprise, based on infringement of their registered trademark. And the thing is that most times we think registering with the CACs, that's the only compliance checklist we need to fulfill. But today I'm telling you that it goes beyond going to the CAC. There are other things you need to do. What about that name? What about that logo? You only registered it, but is it protected? That is the reason why you need to register your trademark. So back to the SANOFI. So SANOFI sued two companies, one enterprise, on infringement of their registered trademark, stating that they registered their trademark before the two companies and enterprise registered theirs. And then they wrote to the Corporate Affairs Commission telling them to delist that name from the register, which the CAC also wrote to the enterprise, wrote to the company, and then they refused to do that, leading to legal issues you do not want to happen in your business. So moving forward, so before I go into today's discussion, what are the benefits of registered trademark? Most times I tell people, trademark your name, trademark your logo. There's one that told me, let them steal that name, let them steal that logo. I would like to say that registering your business or incorporating your company is not the only legal compliance you need to fulfill, or you need to take off that list. Trademark is also one of them, and I will tell you that trademark is not even the only it's not only the only legal compliance you need to fulfill. There are other things based on the sector or the industry of your business. So what are the benefits of a registered trademark? So the first one is protection of brand and identity. So a registered trademark would protect your brand. Once you register a business or you incorporate a company at the Corporate Affairs Commission, it does not guarantee protection of intellectual property, which is what I said. It does not end at CAC. It goes beyond that. I just want you guys to know that CAC is just the first step, which is what those companies that were sued and the enterprise thought they did. They thought they registered this company first. So where is the French pharmaceutical company coming from? But the thing is that the French pharmaceutical company registered their trademark before these two companies and enterprise, before they registered, and started business, which was the reason why they wrote to the CAC to delist that company from their portal. So most business owners think that the only compliance they need to fulfill is registering their enterprise or company with the CAC, but compliance checklists actually go beyond incorporation, like I said earlier. So the mark, the logo, maybe words, maybe both, and images you use for your brand or as a business owner can only be protected under trademark registration. Of course, you have the name. The logo is not yours. And then before you even think of registering your business or incorporating your company, you need to conduct search. And I'm not saying search at the CAC alone. I'm saying search at the trademark registry. There are some names we are using that is at the trademark registry. We find out that this name basically is not yours because there's someone else using that name. You just think the name is actually available. What's the sense of using a name and I can't trademark? It's not better I do the right thing. So once you are conducting search, you search the trademark registry. So don't just stop at the CAC registry. Conduct these searches. So registration will actually prevent unauthorized use of this trademark by a third party, and then you could also bring legal actions upon infringement of that mark. So imagine there's someone or there's a business using that trademark. Because you've been able to register your trademark, you can actually sue the person because that right it belongs to only your business, belongs to only you, and you can sue a third party infringing on that right. So the rights of the registered proprietor are also protected under Companies and Allied Matters Act 2020, which is the CAMA. The act provides that no business or company shall be registered by a name which would violate or conflict with any existing trademark registered in Nigeria unless the consent of the registered proprietor has been obtained. Now, let's go back to SANOFI as a case study. Like I said, if they knew that name was registered or they searched, because there's no ignorant in law, if they had searched, then okay, and I still want to use this name, the next thing for you to do is write to the owner of that name. Okay, I want to use this name, I want to do this, I want to register. And then if he gives you consent, good for you. But if he does not, you have to look for another name because you registered that name first. So one of the other benefits you can enjoy, I've said this but I want to say it again, is exclusivity, licensing. So once you register your trademark, so it gives you, or it grants you exclusive rights as the owner of the mark, and then it helps you distinguish your goods and services. So once a trademark is registered in one or in the multiple classes, because there are various classes to trademarks, it prevents others from using such trademark or similar marks on maybe both, like I said, without the license or authorization of the trademark owner. So before they even use your mark, imagine you're the one with the registered trademark, they will have to write to you, they will have to ask for your consent. It excludes other person, and you also have the right to bring legal proceedings against the person because you registered the trademark, and then you are protected by the law. That mark is protected by the law, and they are basically infringing on that right. So the other benefits you would enjoy for registering your trademark is statutory protection. Like I said, the Trademark Act actually governs the registration of trademarks, and it confers rights on the owner of such marks that are registered. So a trademark proprietor may enforce, and if you are the owner of the trademark, you may enforce your statutory rights against unlawful use by a third party or infringers. anybody infringing on that right. So legal proceedings can be instituted against such third parties or infringers to protect further unauthorized use. You are trying to tell them to desist from using that mark. Most times, when people use, imagine me using Pepsi logo, a logo that I know is already in existence. I'm trying to mislead the public, and that is what the government do not want. They don't situation whereby another person will be misleading people or misleading the public with your own logo, which is why you can sue. So registration of a trademark by the owner is a prima facie evidence of the validity of the claims of ownership over the mark. So basically, the mark belongs to you. How will I put it? You are being protected by the law. So the fourth benefit you can enjoy is the uniqueness. The mark it distinguishes your product from other products. It makes your product easily accessible. Customers will know, okay, this is your product. There's no how you will see Pepsi logo and you don't know this is Pepsi, and there's no how you will see Coca-Cola logo and you don't know this is Coca-Cola. I'm just trying to lay emphasis on how to distinguish. So most times your customers are looking out for this logo. So imagine where there's different type of chin. There's no name, just the logo. How will people be able to identify you? How will they be able to distinguish your product from other products? So but once they already know your logo, people are able to, it gives you that uniqueness. It distinguishes you from other products, other goods and other services. So it helps customers from being misled or deceived by a competitor in the same industry or sector. I'm not the only one doing this product, and most times the idea for the logo comes from what I'm doing. Okay, maybe hair, and there's something hair. The other branch is doing something hair, and you have to make sure that there's a way you distinguish. And trademark is the way you can distinguish your logos. Imagine when you've come up with a logo, you've registered, and someone is coming up with a similar logo, similar design, similar color. You can sue, and that's one of the things you will enjoy. And trademark helps you, helps your product be unique. It helps you stand out. Your customers will be able to identify you. So a registered trademark, when deployed effectively, will improve your brand awareness and the overall commercial value of your company's products and services. So the fifth benefit you can enjoy as a registered trademark is value and quality of goods and services. So based on its popularity, a registered trademark influences consumers' decision. I see a product from Pepsi and I say, if I can enjoy Pepsi, I can enjoy this. And then based on the fact that you trust Pepsi, you get any item coming up from Pepsi. So imagine if there's a infringer or a third party using Pepsi logo. Of course, if the infringer is already misleading the public, and then you get the product, and it took them years to actually build this reputation, which is why some of them will write to you first before they take legal actions or proceedings against you. And you can also, if you are the owner of the registered trademark, you can also write to them telling them to desist from using that name. Failure to do that, you would institute a legal action against them in court. So for instance, there's no how you will see half-beaten apple and that is an Apple product. This product belongs to Apple. Even if it's AirPod and you're saying half-beaten apple, then you know that the product belongs to Apple. That is one of the things you enjoy as one of the things you enjoy once your trademark has been registered. People know you. It gives you this uniqueness, and then value and quality of goods and services, which is what you can enjoy. So the trademark will signify that the value and quality of such devices, Apple products, and it generates tremendous income for its owners through directories. You can make profits. Most times, imagine I'm the owner of this half-beaten logo or half-beaten apple, like I said, and then there's someone using that same logo, and the person starts inventing new products. The person will start converting my customer to his customer, my customer to our customer, based on the fact that people already identify me with the half-beaten apple, and then before you know it, they are not only misleading the public, they are also ripping me off of my how will I put it? Should I say income or profits? They are basically ripping me off my profits, which could actually lead to me instituting legal action against them. So the source and origin of goods and services is recognized and validated through consistent use of trademark belonging to any business. You have to use this logo consistently. Let people know you with that logo, and then maybe you register that logo is on your product. Let your customers know this is your logo. Wherever they see this is you. So I'll be moving on. So there's a question people would ask based on the SANOFI case, the recent case, is that can an enterprise or company register an existing name or trademark? No, you cannot. So before you register a business name or company, the first step is to run a search and you check the availability. Is the name available before running a search? Sometimes most of us will say the mistake is from CAC, but don't let us forget CAC gives us that how will I put it, that platform where we can check if this name is actually available, and you also need to check the name at the trademark registry to see if the name is available for use. So before you submit your name for reservation, you check if the name is available. So there are instances where business owners, they use a certain name for it. They've not registered their business. I think that's where the problem is going to. You are using a name, everybody already know you as a particular store. I can't count how many store, I don't want to say the name, the same name, different people that I have met. And the fact is that they are all on the street of Instagram, they're all on the street of Google. How do you distinguish yourself from one another? And if I can guarantee you that there's one person amongst those people using that same name that has registered and trademarked that name. But that's not what I'm about to discuss right now. So there are instances where you do business, or a business owner has been doing business for 3-4 years, or you're in first year of business using a particular name without registering. So it is not at the point of registration you now find out that there's a company using that name, or and then I already have followers, I already have customers, people, they know me with this name, what do I do? Then you start thinking of something similar to use. Please don't do that. That's the advice I will give you today. Please do not do that. Most times registering similar names could actually mislead people, and then the person that registered that name first could actually sue you. In the case of SANOFI was the first one to register, to have that mark or logo registered before the other SANOFIs came in and registered. So imagine having 3 SANOFIs, SANOFI Nigerian company, like, I don't want to go into details, but they're different. If you see that your name is already in existence, I would advise you to look for other names. Something about business or company is that someone once said that it is seen as your baby. I know there are different children with the same name, but don't want to give your child or your baby a unique name that can help you distinguish your child in the market. So that's what I would say. So make sure it's not after you've done business for years, you're about to register, you now find out. Register your business now. Go to the trademark registry and check if the name has been registered or if the name is available before doing that. Make sure you see your business expand. You don't just say, let me just register along the way. Maybe in 4 or 5 years to this time, I will now trademark. There's somebody with that same thought. It's just that it's not up to 4 years. They've registered that trademark before you, and they don't think that Canva design belongs to you. It has to be a unique design. You can't just come up with Canva design and say you want to go and register that Canva design. I'm just saying. So sometimes most business owners fail to search trademark registry, or they fail to check if a mark has been registered before they incorporate their company. So where a company on its first registration registers a name that is identical or similar to an existing company, that could actually mislead, then CS would ask you or write to you to change your name. There are 2 types of changing of name. You could change your name voluntarily, and it could be involuntarily because your name is similar to an existing company according to section 30 of CAMA. So they could write to you to change it. So in this recent case, that was what happened. See, when SANOFI wrote to CAC that there's a company with that name and they would like, they said what they wanted, and CAC wrote to the 3 SANOFIs telling them to change the name as there's a registered trademark with that name, which they refused. They did not change the name. I do not know why. So you could actually change your name voluntarily or involuntarily. So I will go back again. A company or an enterprise cannot register a name that is already existing or that's already in existence. You can't do that. Even similar names which could mislead and you could, deceive the public. So the other question that people asked when they read that case was, so does registering a similar name suffice as infringement or unlawful use? Yes. So when you register a similar name and maybe a logo is saying, I've been using this name for a long time, people already know me, why don't I just add Shinap, I'm just saying, to the name so that people will know I'm still the same person, just that you are trying to mislead people. Because once they are looking for that name and they can't find, and they are seeing a name that's similar to that, they'll say, this is the product I use, this is what I use. And customers would start, you are basically deceiving the public. There's no, I don't want to sugarcoat it. So yes, you cannot, yes, registering a similar name to an existing name count as infringement, and third party using it can be sued for passing off, and they can also ask you to forfeit. So there are certain things we need to note when we're registering an existing trademark by a third party. Because I know that some of us, after we've said this, you still go ahead to register that name. So if you are going ahead to register that name, I want to tell you some of the implications you need to look out for. Number one is infringement. So basically, unlawful use of a registered trademark is referred to infringement, trademark infringement, and you can be sued. So this occurs when a third party uses a registered trademark or logo that is identical or similar to registered trademark in a way that it can create confusions, or it can mislead the public, or even mislead their consumers. So this confusion could relate to the source, origin or affiliation of the goods. It's like, it's Pepsi that did this biscuit and it's going to be sweet. If I can enjoy Pepsi, I can enjoy this biscuit. Meanwhile, they just kept Pepsi logo. It's not Pepsi that did it, it's another person that's trying to pass off as Pepsi. That's the English I need to use. Pass off as Pepsi, and then people buy it. So it basically counts as infringement. Before you go and register a similar name, just know that you are infringing on the existing name that is on ground, or the existing company already. So the other thing you need to look out for is likelihood of confusion. After you have infringed on that other person's rights that they can sue you for, you are also causing confusion to their customers, to consumers. You are misleading the public, let me put it like that. So one of the central concepts in trademark law is that it is the likelihood of confusion. So if the unauthorized use of a trademark, of a registered trademark, is likely to cause confusion among consumers, the court may find that the trademark infringement had occurred. So imagine you did it and you say you don't know. No problem, you don't know, but they will have to check, did that mark cause confusion? Did it mislead people? Did people buy it because they thought the item was a product, or was like an affiliate product of Pepsi? That's the example I'm using. So some of the factors, such as similarity of the marks, the similarity of the goods or services. You cannot, Pepsi, and you put that same logo on a drink, and the Pepsi is on a drink too, and you say it was a mistake. And then the channel of trade that are considered in determining likelihood of confusion. Then the other thing you need to look out for is the remedies. When they sue you for infringement, and then they also bring it out that there was a likelihood to confuse people or to mislead the public, know that you may be, asked to, compensate the other party. Let me put it like that. Maybe asked to compensate the other party. So if a trademark owner discovers unlawful use of their registered trademark, I find out that there's somebody using, if Pepsi finds out that there's somebody using their logo in a very unlawful way, they can take legal actions against you for infringing on their rights. And the remedies for trademark infringement may actually include injunctive relief, which is urging the third party to stop using that trademark. Imagine that name that you're using to make money, people already know you with, or they know you, they can relate your business with. You can't use it anymore because you're basically infringing on that business, on that company's rights. I can't imagine how sad you'll be. Most times you would even lose money. Imagine them looking for you and they can't find you because you tried passing off as another company. And then monetary damages. And in some cases, destruction of infringing goods. So imagine you already had a look-alike Pepsi with Pepsi logo. They could actually order that product be destroyed. I know the product was passed off, but imagine the amount of money you use in making that product, and then they ask that the product be destroyed. I don't know, like, where the person wants to start from. Is a whole lot of money. So in SANOFI's case, the court granted, or they ordered that injunctive reliefs. They also directed CAC to deregister the name from their lists. So basically, they've been doing business for years, but their name will not be on the CAC register again. They will have to register with another name all over from day one. Imagine they've been doing business for years and customers already know them with that name. They can't do business with that name again. I don't know how they want to tell customer, or what they want to tell customer. I don't know. But customers are out there looking for you with that name, and then the court has already ordered you not to use that name, and then they already granted or ordered injunctive reliefs against you, and they also awarded damages to the main owner, which is the SANOFI, that's the pharmaceutical company, for violation of his intellectual properties, which is the things that could actually happen once you use a registered trademark unlawfully. So it is important that trademark owners, potential users of a trademark, to be aware. You need to be aware of these rights and responsibilities. Trademark owners should actively monitor. I think that's the only way they can. They should actually actively monitor their trademarks to ensure that they are not being used unlawfully. You check, okay, because most times some of us register this trademark and we forget. It is until when someone calls our attention that I saw somebody using this logo. Is it not your logo? It's my logo. So imagine they not call your attention to it. Do you know how they've been ripping you off that you don't know of? And then trademark owners should monitor their logo so that they will know who is using their logo unlawfully. While potential owners or potential users should conduct thorough trademark searches to avoid infringing on someone else's rights. In the process, I'm sure once you have the idea, you can't wait to kickstart that idea and say, I'm registering this. But before you get excited about somebody else's trademark that you don't know existed, please conduct search. It is important. And then, if you believe your registered trademark is, maybe you're the one suffering it now, they're using your trademark, we recommend that you consult a legal practitioner. I know sometimes we are pained when you hear there's somebody doing a drink with your product, or you storm off to that office, boom, 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 you want to go and fight. Please do not do that. Consult a legal practitioner who specializes in intellectual property law to help you assess your option, and they could also determine the best course of action. Is it by writing to them? Do we need to go to the police station? There's some things and there are some procedures you need to follow, which you cannot be able to do that. You need to consult a legal practitioner. So I hope you've heard, and you can take one or two things from what I said, and you can also drop your comments or question in the comment section if you have any, and we can't wait to see you same time next week. And I hope you enjoyed today's session, and your host still remains Tomi Ogunle.